a professor at the Université Libre de Bruxelles, a researcher at the International Law Center, and chairman of the Francophone Network of International Law. He is author of various articles published in national and international journals. Mr. Dubuisson provided legal counsel to Palestine in the case concerning the legal consequences of the construction of a wall in the occupied Palestinian territory before the International Court of Justice. Mr. Dubuisson has a law degree, special degree in international law, and doctorate of law from Université Libre de Bruxelles. You have the floor, sir.
Merci, Monsieur le Président. Je voudrais tout d'abord remercier chaleureusement la délégation malaisienne et les autres pays qui coprésident cette réunion pour m'avoir invité et m'avoir donné l'honneur et le privilège de faire cette présentation devant le Conseil de
sobre el tema de la colonización israelí. Y confieso que me ha dado una sensación de repetición y siempre se repite una y otra vez lo que se ha hecho, se mencionan las mismas reglas internacionales y se constata que se
Now, in the few minutes that I have before me, I will try to give you a few ideas about the possible measures which could be used to fight against the continuation of settlements and to see what mechanisms in international law can be mobilized to this effect. Of course, there is absolutely nothing new to say about the illegality of Israeli settlements in occupied Palestinian territories. As you know, settlements were declared as going against Article 49 of the Fourth Geneva Convention by many resolutions of the Security Council, by many resolutions of the UN General Assembly, by the International Court of Justice in its advisory opinion on the wall in 2004, and also by all of the states except for the State of Israel. Settlements are also contrary to the right of the Palestinian people to self-determination because they create an insurmountable barrier to the existence of an effectively sovereign Palestinian state. As the other speakers have stressed, settlements are also the source of many other violations of international law, and in particular, human rights violations of the Palestinian population, international humanitarian law, and indeed it's the settlement policy which has led to the building of the wall, which involves the destruction of Palestinian homes, the confiscation of land, the appropriation of Palestinian natural resources, the establishment of checkpoints, the establishment of a discriminatory regime in occupied Palestinian territory, illustrated, as was recalled, by the bypass roads. And lastly, it's settlements that justify for Israel the indefinite continuation of the occupation, including the annexation of East Jerusalem. Now, given this protracted illegal situation, is absolutely crucial to determine what are the responsibilities that fall upon the United Nations, and in particular this Council and the member states, and what are the legal means that are available to encourage the State of Israel to end its settlement policy. And I'd like to now devote a few minutes that I've left to these matters. I'm going to look, first of all, at the duty of states, because it's states that must, first of all, take the initiative to take a certain number of measures, including within the United Nations. And then I will look at the question of the responsibility of the United Nations. Now, as I said, these duties, these responsibilities are only the implementation of obligations which are imposed by international law. So my first point would be the duty of states. As I said, settlements create an illegal situation, are a serious violation and systematic violation of the imperative standards of international law. And so in that case, it is up to all states to fulfill a series of specific obligations that require the adoption of positive measures. First of all, they must cooperate in order to bring an end to the serious violations of international law. And secondly, they cannot or they must not acknowledge as being illegal an illegal situation. They must do nothing which could lend support to the continuation of this illegal situation. And lastly, the Fourth Geneva Convention establishes for the states parties the obligation to respect international humanitarian law, and in particular to respect the prohibition of settlements which are in Article 49 of the Fourth Geneva Convention. Now, all of these obligations have been explicitly confirmed by the International Court of Justice in its advisory opinion, which was rendered in the matter of the wall in 2004, and they were also confirmed by the General Assembly in the resolution that followed that opinion. In applying its obligations, states must therefore take individually and collectively effective measures aimed at respecting the prohibition on settlements and not to lend any type of assistance or support to it. And the implementation of those obligations is particularly crucial when it comes to the economic sphere. In this respect, the very close link that exists between the economic activities in the settlements and the violations of the rights of the Palestinian population have been recognized by many resolutions of the Human Rights Council. And in the last resolution adopted in March 2016, the Council said, and I quote, "It was concerned by the economic activities that permit the extension and the consolidation of settlements, and aware that the conditions for agriculture in the settlements violate the legal norms, including the exploitation of natural resources of occupied Palestinian territory, including East Jerusalem, and asks all states to respect their legal obligations to that effect, and to respect their legal obligations to this effect. States must adopt a set of measures designed to ensure that humanitarian law and human rights law is respected without lending any support to the expansion or the maintenance of the settlements. And very specific measures can be mentioned to this effect. First of all, banning the imports of products that come from the settlements, ending all financing of entities established in the settlements. And thirdly, the third specific measure is adopting effective measures on national companies carrying out economic activities which are linked to settlements. And this, of course, refers to the implementation of the guidelines for corporations and human rights adopted by the United Nations in 2011. Now, to speak more specifically, since the production of goods in the settlements allow for their expansion and violates the rights of Palestinians, then we understand logically that the trade in these products must be banned, that the financing of those settlements must be banned, and the foreign companies should no longer do business in the settlements and with the settlements. The adoption of this type of measure would only be the necessary implementation of obligations to ensure that the settlement ban be respected. Some states and some organizations, such as the European Union, have adopted certain measures aimed at the settlements, and I'm thinking in particular of the guiding principle adopted by the European Union in 2013 concerning the financing of research of entities established in the settlements, or the opinion of the European Union concerning labeling of products from the settlements in 2015. But this type of measure remains largely insufficient given the seriousness and the urgency of the situation. To be truly effective, the measures aimed at the settlements must adopt collectively within the United Nations and this leads me to the second point concerning the responsibility of the United Nations. In its opinion on the wall of 2004, the International Court of Justice announced that it believed that the United Nations, and I quote, and especially the General Assembly and the Security Council, must bearing in mind the current advisory opinion, must examine what new measures must be taken in order to put an end to the illegal situation stemming from the building of the wall and the regime associated with it. And, of course, this injunction could be extended more generally to the establishment of settlements. Now, the court, in the same opinion, underscored, and I quote, the urgent need for the United Nations as a whole to step up its efforts in order to quickly put an end to the Israeli-Palestinian conflict, which continues to pose a threat to international peace and security, and to establish in this way a lasting peace in the region. More than 10 years after the publication of that opinion, and almost 50 years after the beginning of the occupation and the settlements in the Palestinian territories, we have to observe that, unfortunately, the United Nations has failed to ensure that international law is respected by Israel, despite the adoption of many resolutions by different bodies. If we want to preserve a chance for peace in the Middle East, it's time to go beyond these simple policies and declarations and to adopt more effective measures in order to bring an end to the settlements and occupation. And from that point of view, we can't help but make a comparison with South Africa as it appeared in the 70s. Apartheid was a violation, a systematic and protracted violation of international law, a situation which was condemned universally. But because of certain political alliances, because of realpolitik, for a long time, no binding measure was able to be adopted by the Security Council. It's only with the pressure of certain groups of states within the United Nations, with pressure and action by civil society as a whole throughout the world. It was only in that way that the Security Council ended up deciding in 1977 an arms embargo aimed at South Africa, and also in 1985 it adopted a resolution which urgently asked the states to take economic measures against the apartheid regime. Today, we should be inspired by that precedent and begin a process of adoption within the General Assembly under the impetus of groups of states, of specific measures which would make it possible to combat against these settlements, starting, as I said earlier, with the banning on the import of products from settlements, banning any financing of entities established in the settlements, and the adoption of effective and efficient measures against foreign companies that invest in the settlements. Now, that type of measure is aimed particularly at settlements, and it would have a greater chance of achieving a wider consensus within the General Assembly of the United Nations. And afterwards, we could hope that the Security Council would end up no longer being blocked by the situation and would follow the example of the General Assembly as it did in the case of South Africa. Our option as well, another option, would be to ask once again for an opinion from the International Court of Justice, another opinion concerning the specific consequences that states should draw from the continued activity of settlements in the Palestinian territory of Israel. This would make it possible to point out exactly what measures states must adopt in order to bring an end to settlements. And now I come to my conclusion. Being an international law expert and working on the question of the Israeli-Palestinian conflict is sometimes a bit depressing. On the one hand, all of the rules are very clearly established and stipulated by the United Nations. And on the other hand, those rules are absolutely not respected and not upheld, and no specific measure is taken in order to make them effective. But if there is one hope for the Palestinian people to see one day a state and also to see freedom, it's because they could take advantage of international law, because international law is at their side. And now the United Nations and the member states must fulfill their responsibilities and make the rights of the Palestinian people effective. Thank you very much.
I thank Mr. Dubuisson